value about promoting fairness in trial proceeding, you would or the ocular evidence that New York State wanted provided by public access, which is that you make sure that the man is not, or woman, is not mistreated, not tortured, that they actually did it, and everybody can observe that as well. Chief Justice Berger said in the Richmond newspaper's case that the public doesn't necessarily expect the system to be infallible, but it's harder for the public to trust a proceeding that they're not allowed to observe. So there's that value. Well, we bundled up all this evidence, the historical evidence, and presented it to Judge Schnacke, and kept our fingers crossed that he would allow us access to the proceeding, and then would allow us, he would order the state to allow us to use the tools of our trade. After we did that, the judge set it down for a hearing, final part of the trial, and we walked in and he put his feet up on the bench and leaned back and delivered his opinion, orally, nothing written, completely seat of the pants, sort of stream of consciousness, in which he ruled that it seemed unreasonable for the warden to shut down the proceeding to press and public, giving no reasons for that, not citing any cases, but we had won the access point. We were entitled to be there. And then he ruled against us on everything else, on all of the tools of the trade. And he found valid 3 of the warden's justifications that they came up with at trial for why television should not be allowed. One was the one that the warden had mentioned in deposition. He hadn't yet thought of the others, which was that television coverage would expose the guards who worked the execution to possible retaliation. He came to that conclusion, the judge did, based on the warden's, I have to say, speculation that someone might someday, somehow, retaliate against those guards if they could see what they looked like. But we had demonstrated during the trial the technology that I'm sure you've seen many times about how you can obliterate the identity of anybody who's on television. You blow up the pixels, or we used orange balloons. Nobody could be identified at all. You've seen orange balloons? Yeah. You can blur them. But the judge said that the warden was not required to trust that the original tape, undoctored, might become public somehow, and the warden wasn't required to run any risk in this delicate process of execution. Second, the judge found valid the warden's testimony that a suicidal camera person working for the television station, carrying a broadcast quality 28-pound then camera around into the death chamber, might hurl the camera at the glass in the gas chamber, breaking the glass, releasing the lethal gas, aborting the execution, and maybe killing the spectators in the gas chamber thing. Even though the testimony at the trial showed that it would be practical to attach the camera in a fixed position on one of the 2 pillars in the room up above anybody's reach and operate the camera remotely. The judge said, you never know what a suicidal camera person might do. And third, the judge credited the warden's testimony that prisoners in San Quentin, and maybe in other prisons, who see an execution on television might be so inflamed by that experience that they would riot or rebel or retaliate against whatever guard happens to be walking past the cell. Even though San Quentin is on a closed-circuit television system, and with a flip of the switch, you could black out the prisoners from seeing an execution. Instead, the state chose to black out the public rather than the prisoners. But the sense of Judge Schnacke's decision was that the warden's in charge here, this is a tough job, and he's not required to run any risk in deciding what kind of news coverage should be permitted of these proceedings. Neither party appealed. There is still an injunction in place requiring the warden of San Quentin to allow public and press access to execution. There may not ever be any anymore. They've been stalled now for several years, and they may never be resumed. But if there is one, it'll be covered. But his opinion, saying that you're not allowed to use cameras or recording equipment, that stands. He relented on notepads and pencils and said reporters should be allowed to use notepads and pencils, but they're issued by the warden. You can't bring your own. So that's where the execution thing stands. I'll show you some of the evidence that we used at the trial. These are sketches by the world's greatest courtroom sketch artist, Howard Brody, who had sketched all of the famous trials and a couple of assassination kind of trials, others the trial of the guy who shot Lee Harvey Oswald, the assassin of President Kennedy. Anyway, he covered them all. He was a great courtroom artist. He had covered the last execution in California, the Aaron Mitchell execution in 1967, and had sketched it. And he remembered vividly that when Mitchell was brought into the gas chamber, his last words, he screamed out, were, "I am Jesus Christ." And there were a number of reporters at the execution. Most of them didn't mention that at all. One of them wrote that he had muttered something about going back to Jesus. But Brody vividly remembered his screaming, "I am Jesus Christ." Well, we used that as a basis for arguing that you needed audio as well in order to capture accurately what had actually transpired at the execution. He did 4 sketches of the execution. There he's dying and finally is dead. The trial attracted enormous media attention from around the country and around the world with a split of everybody had an opinion. They still do. I put some of the more current articles in the Reader about people's opinions on whether executions should be televised. And people who were for the death penalty said, yes, indeed, that will serve as a deterrent to committing capital crime. People should see the result of this. And people who are against the death penalty said, terrible idea, don't put it on television. It just coarse it. Anthony Lewis, for example, great First Amendment scholar, writer, New York Times correspondent, thought this will just add to the coarseness of our society, and people will treat it like football games and beer parties around the executions, and it's a bad coarsening influence on our society. People against the death penalty wanted executions on television, figuring that will create some sympathy for the victims being the condemned person, not the victims of the condemned person's murder. And there was, across the spectrum, there were inconsistent opinions about whether television was good or bad for capital punishment. What do you think? Would it have a deterrent value? That would serve an important public function, provide deterrence to crime. Josh? Mm-hmm. Okay. What do you think? Shrug their shoulders. Watching the guy go to sleep, big deal. People might watch one execution. Are they going to watch the next one? Yeah. It's a sordid subject. Related to it, let's go back a step, because during the trial of this case, the Attorney General repeatedly reminded the judge that cameras are not allowed in federal courtrooms for trial. How can they say that they're entitled to go into a maximum security prison and televise an execution when they can't even be here in this public courtroom? And there's some history on televising trials that you might as well be aware of. When television first became viable, economic, and portable, you didn't have to do it in studios and so on, there was a trial in Texas in a state courtroom in Tyler, Texas. The defendant was Billy Saul Estes, who was a crony of Lyndon Baines Johnson, the president, who was a big-time swindler. He had tanks full of what was supposed to be salad oil, I think it was, and was actually water, and he was defrauding a bunch of people. And since he was a high-profile, politically connected guy, when his trial came up in Smith County, Texas, the media wanted to cover it with television. The judge allowed television of the Billy Saul Estes trial. And the courtroom was basically given over to the television media. And in those days, these were Neanderthal days, television cameras were enormous and had to be mounted on big tripods, and they had huge cables going like spaghetti around the courtroom. The jury was fascinated with the television process. They had big theatrical lights that they needed for capturing an image. And it was like a television studio that had been created but been allowed by the judge. Well, Estes objected to the television coverage of his trial, saying that he was being denied a fair trial. The jury's all distracted by all this television stuff. He was convicted. His case went to the Supreme Court, and the court reversed his conviction on the grounds that he had been denied due process of law in the procedural sense. He had been denied a fair trial because the trial had been televised. And the Supreme Court basically advised the courts of the land, don't allow television of trials. It simply will contaminate the process. And there things stood until 1981, when Florida, out in front of the other states, decided that they would experiment with allowing television coverage of trials, and they allowed, the court allowed coverage of some guy named Chandler's criminal trial over his objection. He was convicted. The case went to the Supreme Court, and the court said, simply televising your trial does not deny due process, does not deny you a fair trial. You have to show, you criminal defendant, that you were prejudiced in some specific way by television coverage of your trial. Chandler had done that, and therefore his conviction stood. Well, what was different between Estes in 65 and Chandler in 1981 was basically the technology. By 1981, you had much smaller, unobtrusive cameras. You didn't need all these cables all over the place. You didn't need any extra lighting at all. You could station a camera in the corner of the courtroom, and maybe the jurors or witnesses would notice it was there momentarily, and then forget about it. But the technology sort of overcame the court's objection to televising criminal trials. Then nearly all the states conducted some kind of experiments in televising trials, starting with criminal trials and civil trials. And then they would have the social scientists come in and do studies of the effect of televising trials on the participants, on the jurors, on the judge, on the witnesses, on the lawyers. And basically the studies concluded there were no significant effects. In my view, the player in the scene that is most affected by television is the judge, who will never go to sleep in a televised trial, who will be impeccably judicious, do things that judges ought to do, unfailingly courteous to the litigants and to the lawyers and to the witnesses and to the jurors. The rest of the people don't pay much attention. Lawyers, in fact, don't play to the cameras any more than they do to anybody. After the O.J. Simpson trial in Los Angeles, where Simpson was acquitted in a nationally televised trial, Governor Pete Wilson was so upset by the verdict that he directed the State Judicial Council to conduct a study and make recommendations on whether television should be eliminated from the courts. And they went around the state and had a hearing. I testified, amongst many others. The judges in the state didn't want television. but they ended up with a rule that's sort of a compromise. In California, rule of court 1.150 allows television coverage of trials with the permission of the trial judge. No appeal from that. It's entirely within the judge's discretion whether to allow television coverage or to pick and choose, have television coverage of some part and not the other. Entirely discretionary. The courts have never, the Supreme Court has never decided whether there is a First Amendment right to televise a trial. The states have, now they basically allow trial coverage in the discretion of the judge. The lower federal courts decided that there's no First Amendment right to televise a trial. Yes, you have a right to be there, but not to televise it. And the reasoning was, look, trials are serious, deliberative kinds of proceedings where the witnesses are trying hard to remember what happened, the jurors are focused on who's telling the truth here, the judge is making close judgment calls about what evidence comes in, and you don't want any distraction from that deliberative process that might be caused by television. It's an antiquated view, should have been junked long ago, but it's still the law. So it was true in the televising executions case that we were not allowed to bring cameras even into that courtroom. But because of the reasoning of Richmond newspapers, we were allowed to bring them in, not cameras, we were allowed to get into the execution chamber. Okay, next week is, does the press have any rights the rest of us don't have?